Good evening and welcome to our performance. At this time, we ask that you turn off or silence any cell phones. For the unlikely event of an emergency, take a moment to locate the exit nearest you. Please keep in mind that recording the performance or taking photographs is strictly prohibited. And now sit back, relax, and enjoy the show. This copyrighted program is produced by the Commissioner of Sports. It may not be reproduced, transmitted, or otherwise distributed in any form, and the accounts, pictures, and descriptions of this game may not be disseminated without express written consent. What do you mean I'm not allowed to play Rudy Splinter's new album over my restaurant sound system? They're the best band this side of the Mississippi. You're saying I don't have a public performance license for their music? But I bought a CD at their concert. I could be liable for copyright infringement.
Maybe you've also been told that you can't copy or perform something because it's a work protected by copyright. But what does copyright actually mean? The goal of this unit is to help you develop an understanding of how copyright law works, so that by the end of it you'll have a solid grasp of the fundamentals of copyright law. Today I'll talk about what copyright is, the rights that a copyright owner possesses, and give you a quick tour of the modern copyright statute. So let's go ahead and get started. The first step to understanding copyright is to know what a copyright is. A copyright is a legal right to an original work that's fixed in a tangible medium of expression. This right allows the copyright owner to bring a lawsuit against someone who copies or makes certain kinds of uses of the author's creative expression without their permission. Of course, not every use of a work, or even every instance of copying, is prohibited. As we'll discuss in this unit, there are some pretty important limitations on copyright scope. Limitations aside, the core idea of a copyright is what forms the basis for things like copyright licenses and other transactions involving copyright-protected work. It's essentially the legal fence around a work of authorship. Now, copyright's been around for a long time. In the United States, a copyright statute was among those passed by the first Congress, and it was signed into law by George Washington himself. That statute has undergone significant changes over the last 200 plus years, however. And perhaps more than any other area of the law, copyright law has been deeply affected by new technologies. The next thing to understand about copyright is, what kinds of stuff does it apply to? Basically, copyright applies to what we call creative expression, words, music, art, and much more that's created by an author. The creative expression must also be recorded somehow, whether in print, paint, film, metal, computer memory, basically anything capable of storing information. You can imagine that traditionally this consisted of things printed on paper, but today there are lots of different mediums for storing information, from record discs to mobile phones. There are basically two legal rights granted by copyright: the exclusive right to reproduce, that is, copy the work, and the exclusive right to publicly perform the work. There are other rights that we'll talk about later, but these two are the most fundamental to understanding what copyright is. The first right says that only the copyright owner can make a copy of the work. So if I write a book, other people can't copy that book without my permission. Importantly, the exclusive right to reproduce a work includes not just literal copies of the entire work, such as an exact reproduction of your favorite novel, but also non-literal reproductions. That is, if someone copied large chunks of the book or paraphrased the book. The second right says that if I do something like write a song, other people can't publicly perform that song without my permission. Or if I write a script for a play, other people can't publicly perform that play without my permission. Or if I film a movie, other people can't publicly show that movie without my permission. And often I'll want to get paid for granting that permission. Another thing to know about copyright at the outset is that under modern copyright law, a person has a copyright in a work as soon as their original creative expression is fixed in a tangible medium, such as by writing it down. For example, as soon as I wrote the script for this video, I had a copyright in it. As soon as I took this photograph, I had a copyright in it. This means that for works created today, it's not necessary to do anything in order to get a copyright. The copyright comes into being automatically once the words are written down or the photographer presses the button. Now you might be wondering why we have copyright in the first place. The core justification is that granting exclusive legal rights in a new creative expression provides an incentive for people to create those works. I'm incentivized to create this video because I know that no one else can copy it without my permission. I'm the only one who can authorize the creation of copies. Keep in mind that copyright is just a legal right to an original work of authorship. It doesn't have anything to do with the intrinsic value of the work. Lots of old works aren't protected by copyright, but they're still really valuable creative expression. And trillions of works are being created today and are protected by copyright that have pretty much zero economic value. Take, for example, this photograph of my wall. No one would ever pay for that, but arguably it's protected by copyright. In other words, it's important to recognize that just because a work is protected by copyright doesn't mean that it's valuable. The value of a work comes from the work itself. Copyright just grants a legal right to prevent copying or public performance of the work. Second, a copyright can be transferred. We call it assigned to another person. This means that once someone writes a book, the author of that book can transfer the copyright in the book to the publisher. At that point, the publisher owns the copyright in the work and has the exclusive right to make or authorize copies, or to authorize public performances of the work. Similarly, copyrights can be licensed so that other people can have permission to make copies or perform the work. Licenses can get complicated though, so it's important to first know the fundamentals. We interrupt this episode to bring you a word from our sponsor. Today's episode is brought to you by Title 17 of the U.S. Code. When you visit Title 17, you'll find all sorts of statutory law relating to copyright. Need to know the definitions? Just look in 17 U.S.C. Section 101. Need to know the rights of the copyright owner? We've got those too! Want to read about the law governing transmission of copyrighted works? We got pages and pages of that! Title 17, it's where you'll find the copyright stuff. Now that you know what a copyright is, I'm going to give a quick tour of some of the parts of the copyright statute. In the United States, the federal Congress is authorized to enact copyright law by the U.S. Constitution. The modern copyright statute is codified at Title 17 of the U.S. Code. If you look at the entirety of Title 17, you'll see that there's a lot of law here. In this overview, I'm just going to point out some of the major landmarks. We'll discuss these sections in more detail in subsequent classes. Keep in mind that there's more law than we'll actually cover in this course, much of it dealing with specific areas such as cable television and the recording industry. The first important section is Section 101, which contains the definitions for Title 17. These definitions are very important, and we'll be coming back to them several times. Statutory definitions can really affect the meaning of statutes. For example, take this definition of state, which defines state as including the District of Columbia and the Commonwealth of Puerto Rico, or this definition of performing a work publicly as including the transmission of a work. The next important section is Section 102, which in subsection A describes what's entitled to a copyright. Then in subsection B, it identifies what cannot be protected by copyright. We'll be discussing Section 102 more when we talk about Feist versus Rural and Baker versus Selden. Section 106 describes the statutory rights of the copyright owner. These are the rights that the copyright owner possesses, including the exclusive right to reproduce a work. The main cases that we'll talk about here are Nichols versus Universal and Pickett versus Prince. Section 107 is a very important section. It articulates the concept of fair use, a certain type of use of a copyrighted work that doesn't constitute infringement. We'll talk about this in more detail when we discuss Campbell versus Acuff-Rose. Section 201 addresses the issue of copyright ownership, and it incorporates concepts such as works made for hire. We'll talk about concepts of authorship and ownership when we read Committee for Creative Nonviolence versus Reed. Section 501 provides the cause of action for copyright infringement. This is the legal cause of action that a copyright owner can bring against somebody who violated their rights under Section 106. This section is important because it provides the actual legal cause of action for copyright infringement. And then there's Section 504, which deals with remedies. These are the remedies that a copyright owner is entitled to against someone who has infringed the copyright. Remedies in copyright can encompass both monetary remedies and injunctive relief. We'll talk about remedies toward the end of the course when we discuss remedies generally, but for now, recognize that copyright owners may be entitled to collect money damages from an infringer and also to stop the infringing copies or use.
It's time for a copyright conundrum. Which of the following can be copyrighted? Is it A, a cookbook, B, a new plant species, or C, the English language? If you answered A, a cookbook, you're right. Cookbooks contain creative expression that's been fixed in a tangible medium.
One of the most fundamental questions about copyright law is, what does copyright protect? We could start with the U.S. Constitution, specifically Article 1, Section 8, Clause 8 of the Constitution, which gives Congress the power to enact laws granting exclusive rights to authors and inventors for their writings and discoveries. But it probably makes more sense to look directly at the law that Congress enacted, especially Section 102 of Title 17 of the U.S. Code. Section 102 states that copyright protection subsists in accordance with this title in original works of authorship, fixed in any tangible medium of expression. Based on this, we know that original works of authorship can be protected by copyrights. But just what is an original work of authorship? And does copyright in an original work of authorship prohibit all copying of anything contained in the work, or does it only extend to some aspects of the work? The first case that you'll read in this unit on copyrights is the case of Feist versus Rural. This is a Supreme Court decision that involves a claim of copying over a telephone directory. Basically what I'm showing right here. As you can see, this directory contains a list of people and their phone numbers and addresses. For many years, this was the way that you found someone's telephone number. And really, it was pretty much the only way to find someone's number, other than by asking that person directly or getting it from a friend. As you'll read about in this case, Rural provided telephone service in a particular local geographic area, and it created a telephone directory for that local area. Feist, on the other hand, was in the business of creating telephone directories for entire regions. To do that, it needed the names and telephone numbers of the people in those areas. Feist started out by asking for that information from the local telephone providers, and it entered into agreements with those providers. But Rural refused. So Feist went and copied the names, addresses, and telephone numbers of thousands of people right out of Rural's telephone directory. This was the heart of Rural's claim for copyright infringement against Feist. Think about this in the context of a book. If I copied 100 pages out of Percy Jackson and the Lightning Thief and put those pages in my book, Rick Riordan would have a pretty good claim for copyright infringement. Now, before you start to read this case, I want to clue you in on another statutory section that we haven't talked about so far. That's 17 U.S.C. Section 103. Section 103 talks about compilations, a term that is itself defined in Section 101 as meaning a work formed by the collection and assembling of pre-existing materials or of data that are selected, coordinated, or arranged in such a way that the resulting work as a whole constitutes an original work of authorship. And Section 103 says that copyright can extend to these types of works. But subsection B goes on to add that copyright in a compilation, extends only to the material contributed by the author of such work, that is, the compilation, as distinguished from the pre-existing material employed by the work, and doesn't imply any exclusive right to the pre-existing material. In other words, if I create a compilation of Shakespeare's plays, my creation of that compilation doesn't give me copyright in Shakespeare's plays themselves. It's also important to recognize that it's possible to have many layers of copyright. For example, if someone wrote a short story, and that short story was incorporated into a collection of short stories with the short story author's permission, there could be both copyright in the short story as well as copyright in the collection. Keep this statute in mind as you read through the court's opinion. There's a copy of it right before the case in the book. Finally, as you read through the case, I'd also like you to think about a few questions. First, what kind of policy choices do you see in the issues addressed in this opinion? Take a step back and try to see the big picture. Second, what's the primary legal issue in this case? How and why does the court draw the line that it does? Third, based on this opinion, how would you determine whether something is or is not subject to copyright? And finally, what's meant by thin copyright protection? We'll discuss these questions in the next class. It's been wonderful chatting with you about copyright. Oh, I think that's for me. See you in our next class.